Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 21-1130 et al. Intelligent Transportation Society of America and American Association of State Highway and Transportation Officials, petitioners, versus Federal Communications Commission and United States of America. Mr. Turner for the petitioners, Intelligent Transportation Society of America et al. Mr. Gaiman for the petitioner, Amateur Radio Emergency Data Network. Mr. Novak for the respondents.
Morning. Mr. Turner, you may proceed when you're ready.
Thank you, Your Honor. May it please the court, Joshua Turner on behalf of transportation petitioners, ITS America and the American Association of State Highway and Transportation Officials. The FCC has taken an extraordinarily broad view of its authority to determine what is in the public interest. So broad that they say it's not even impacted by Congress's decision to mandate the creation of a program designed to reduce the nearly 40,000 deaths every year on the highway. Is fully supporting that congressional priority in the public interest? The FCC says no. In doing so, the FCC has, in DOT's own words, and this is at JA 536, substituted its own judgment for transportation safety matters for that of transportation safety stakeholders, whose overriding concern is trying to make the roads safer, and who believe that the kinds of capabilities that can only be provided in the full 75 megahertz safety band are critical for doing so. There's a reason that my clients, which include all 50 state DOTs and a cross-section of transportation safety professionals, brought this challenge. And the groups like the American Traffic Safety Services Association, National Safety Council, and Mothers Against Drunk Driving, among others, are amici supporting our position. To understand the commission's error, you really only need to focus on a few paragraphs of the order. The first, paragraph 123, and that's at JA 639, is the only place that the FCC substantively addresses Congress's enactment of the Transportation Equity Act. In just a few sentences, the order waves Congress's views aside and concludes that, quote, all Congress required, unquote, from the commission was to complete a rulemaking following the statute's enactment. The commission doesn't give any serious consideration to the congressional priorities embodied in the Transportation Equity Act, nor does it wrestle with the fact that Congress also delegated authority to DOT to design and manage the Intelligent Transportation Program, and that it is DOT, not the FCC, that has the expertise to do that.
Mr. Turner, as I read the Transportation Equity Act, it doesn't require really anything in particular other than attention to the emerging intelligent transportation, possibility. It sets up a lot of, urging study and drawing on various expertise and considering this and considering that. And so I just wonder what safety benefits does it require that support your claim that safety benefits are certainly lost as a result of the order you challenge? Like, what is the act that's required that wasn't taken?
Well, so Your Honor, a couple of points on that. I agree with you that there's no specific safety benefit that is mandated in the program, because what the program does is give the authority to DOT to design and manage the program. And Congress understood that this is a dynamic situation and that there would be safety benefits that would occur over time that DOT should consider and put in place.
What do we make of the fact that DOT no longer has that position?
Well, Your Honor, two things on that. One, I don't think we can confidently say that DOT no longer has that position, because what the United States filed was a brief saying we have joined the FCC's brief after considering all of the various different equities, including the FCC's position. They notably did not say that DOT had changed its position, but more importantly,
it doesn't matter. It doesn't matter. Are you familiar with the famous case? Where do I have it? The Castle case that Judge Wald wrote back in the early 80s.
No, Your Honor, I'm not familiar with that off the top of my head.
It's a wonderful essay on the unitary executive, pointing out that President Carter was entitled to ignore EPA's views, and she made clear in that opinion that single issue agencies often don't have the right answer. And the
Understood.
president's entitled to consider broader spectrum.
Understood, Your Honor. I think that, but the important point here is that at the end of the day, the order being challenged here is an order by the FCC. And the Administrative Procedures Act requires the FCC to have evidence in front of it that it can rely on. And so what matters here is not what DOT thinks about the order now, today, what the president thinks about the order now, today. What matters is the evidence that DOT put into the record. And that's at JA 536. In the November 9th letter, DOT issued a scathing letter saying, you haven't listened to us, you haven't consulted us, you haven't addressed any of our objections to this program. None of the stuff that
But
you're
in light
doing
of
is
the fact, in light of the fact that the government has taken the side of FCC, an independent regulatory agency, as against a government department, can't we conclude the government department's views are no longer espoused by the executive branch?
Your Honor,
why are they relevant anymore?
Well, I think the government's, the independent agency's views were relevant at the time that the FCC issued its decision, because that was the record.
I'm not talking about the independent agency. I'm talking about DOT.
Right. I'm sorry. The DOT's views were relevant at the time that the independent agency issued its decision, because that was what was on the record before it. That's all that the independent agency had. It had to consider the record that was before it and make its decision. DOT said, you're not doing the right thing here. And that's relevant because DOT has that expertise in determining what is and is not a transportation safety function.
So the commission did have extensive comments, as you point out, from DOT, considered those. What more would the commission have had to do to fulfill its duty of consultation, in your view?
Well, so a couple of things on that, Your Honor. I mean, first of all, we think that the duty of consultation is an independent duty that is established by the Act. And you can't just say, oh, we took public comment and we fulfilled our duty of consultation. Because if all you were going to do was take public comment, then the statute wouldn't need to say you need to consult, right? I mean,
but you didn't make that surplusage argument in your opening brief, did you?
I'm sorry?
You didn't make that argument that the duty to consult would be rendered statutory surplusage if all it meant was that you had the same opportunity as everyone else to comment under the APA. You didn't make that argument in your opening brief.
I apologize, Your Honor. I haven't looked back at our opening brief to find that, but I think we certainly are making, if we did not use the term surplusage, we certainly made that point, which is that the consultation obligation is an independent obligation that is broader than simply doing what you normally do.
There isn't any dispute that there was consultation when the 75 megahertz of the 5.9 spectrum was initially set aside back in whatever it was, 1999, right? There was consultation then.
There did seem to be consultation then, Your Honor. And so that's another thing that I think.
But wait a minute, why isn't that enough? Why isn't that enough?
Because I don't read the Transportation Equity Act as being a one-time shot the way that the commission does. The commission seems to say, look, the only thing that we needed to do was consult once, and then in 1999 we were done. And then after that, our authority under the Communications Act springs back into place, and we don't have to think about the Transportation Equity Act again. And I don't read the statute that way, and I submit to Your Honor that it wouldn't make a whole lot of sense to read the statute that way, because as we say in our brief, if that were the case, then the commission could simply turn around the day after and decide that it was going to ban intelligent transportation programs in the United States, and no one would have a thing to say about it. Now, the FCC
might be arbitrary and capricious. I'm not sure that it would violate the act, but think about it this way. Let's say at the beginning in 1999, what the FCC did was allocate 30 megahertz of spectrum, and what DOT wanted was 75. Does that mean that every single time the FCC allocated any other spectrum to any other party, that the FCC would have had a duty to consult with DOT because DOT says, hey, we should be getting that? That seems impossible to me. And that seems to flow from your reading.
No. I think, Your Honor, that is a more aggressive reading than we would give. Our point is that to the extent the FCC is acting on the intelligent transportation program. Now, Your Honor, if the commission were to say, we've allocated 75 and we're thinking about taking 15 away from that, then yes, I think that triggers the duty to consult. If Your Honor is saying that because there's a duty to consult anytime spectrum becomes available, they need to ask DOT if it wants it first. I mean, I don't think there's a right of first refusal here.
Tell me,
Why
what do
wouldn't there
you,
be
what-
under your reading if there's a continuous duty to the extent that it has an impact on the intelligent transportation program as DOT defines it? And if DOT at the beginning said, we need 75 megahertz to do all this, real time line of, no line of sight technology, and you've fallen short, then don't they have a duty to consult every time that spectrum gets allocated elsewhere? Under your reading?
No, Your Honor, I think they have a duty. I think the duty to consult is continuous, but I don't think that it is the case that the commission therefore has to give a right of first refusal to the DOT. I mean, I just don't see that in the statute.
Not a right of first refusal, but a right of consultation in your reading. I'm just taking what I understand to be your reading, that it's not a one-time obligation where this is sort of something coming on the scene. Let's all consider it. Let's get DOT in this business, but no real specifics about what DOT needs to do. And it, FCC
Well, and Your Honor,
participated in that inaugural moment.
But Your Honor, so 2 points on that. I think one, the alternative is just as crabbed, right? The alternative reading is just as weird, because if you assume that the FCC only has the duty to consult once, then you end up in a situation where the commission could reassign the spectrum without any consultation, without even hearing public comment from DOT. And that doesn't make a lot of sense.
Well, in this case, they did have public comment, right?
Correct.
Why wasn't that adequate? Even if you were legitimately had raised the consultation in your opening brief, why isn't that legitimate?
So, Your Honor, I think in our opening brief, we make a couple of points here, right? We say that the Transportation Equity Act imposes a heavier burden on the FCC
No,
here.
I'm just asking about consultation now. Department of Transportation is perfectly happy as far as we're concerned in this case at this point with the consultation they got.
So Your Honor, I think the consultation, if you had seen real and meaningful consultation, you wouldn't have seen DOT in November of 2020 coming in and saying you didn't talk to us, and you ignored all of our.
Apparently, that's not their view now.
Well, but Your Honor, I mean, again, sort of going back to the point, I think the view that matters is the view that predated the order, because that's all the FCC had in front of it when it was making the decision, and that's the record.
It certainly had the comments, didn't it?
It did have the comments, yes, Your Honor.
And why wouldn't that be adequate consultation?
Because I don't believe that
Did they have to meet in a telephone booth?
No, Your Honor, but I do think they have to do more than what they would be obligated to do with any other party.
And what would more be?
I think in this case,
on the phone.
well, in this case, we don't know what they did, because the commission didn't recite anything in its order explaining what it did in terms of consultation beyond saying, hey, we took public comment.
What else would be required? Tell me what would be required.
I think one thing
going to lunch.
I think, Your Honor, you can understand in part whether or not the consultation was meaningful by the results of the consultation.
Oh,
now, that doesn't mean. No, I mean, Your Honor, I think when
in other words,
DOT,
the FCC, your case is the FCC was obliged to take into account the original position of the Department of Transportation and rule in their favor.
No, Your Honor, that's actually not my case. That's the case that Mr. Gaiman is going to argue. But my point is a subtler one. My point is that the FCC was obligated to give DOT's views in this matter considerable weight, and they were obligated to do that for a number of different reasons, right? One is the Transportation Equity Act, but the other is that the DOT is the expert agency on these matters of transportation policy, and the FCC is not. And even if the Transportation Equity Act did not exist, our point in our opening brief is that the commission didn't give sufficient weight to what DOT and other transportation safety stakeholders, not just DOT, it's also all 50 state DOTs who are my clients, every other transportation safety stakeholder, all said 30 megahertz is insufficient. Who did the commission listen to? The commission listened to the cable industry. The commission listened to Open Technology Institute and Public Knowledge. If you look at footnotes 84 through 88 of the brief of the order, the part where the commission says, hey, we think that 30 megahertz is sufficient, those are the people that they're citing. And our point is, it's arbitrary and capricious under any standard for the commission to take the word of the cable industry on transportation safety policy over the word of DOT, all of the state DOTs, all of the other transportation safety stakeholders who said, this can't work. And what you're doing doesn't fulfill the goals of the Intelligent Transportation Program. So take the TEA out of it, they still lose on arbitrary and capricious.
Your clients didn't submit anything on standing or really argue it. What's the basis of the standing?
Well, Your Honor, our clients, I think we did recite in our brief, our clients are licensees in the ITS spectrum. We are dramatically affected by this order. ITS has licensees who will have to spend money to rip and replace their units with these new units that the commission wants them to install.
But that's about the change from DRSC to CV2X, and that's not. I thought that wasn't really even challenged.
No, I'm sorry, Your Honor. It's about both because our clients use the full spectrum now, and so we'll need to change their units to address this 60% smaller home that the FCC has given them. And so, yes, we are directly impacted by the order. And of course, both of these clients participated in the proceeding below. And so I think our standing is fairly self-evident. And in fact, I think the FCC acknowledged our standing on that point.
Right, but we have an independent duty, and typically we have a little bit more chapter and verse about, which members of an association are doing what, and actual evidence explaining, averring to us, because this is the first Article 3 court you're in, explaining to us what factual basis we can rely on for standing.
Yes, Your Honor, I do believe that we addressed that in our brief, and we made the point that we have, the commission talks about the tens of thousands of these units that are operating across the country. Those units are being operated by members of our association.
Maybe in your reply, if you have a chance to look at your opening brief between now and then, you could address the concern that you forfeited the argument that FCC's consultation with DOT was statutorily insufficient.
Certainly, Your Honor, I will.
Right, colleagues, further questions?
No.
All right, Mr. Turner, I think we used all your time, but we will give you a couple of minutes for rebuttal.
Thank you, Your Honor.
All right, now we'll hear from Mr. Gaiman. Is it Gaiman or Gaiman?
Gaiman.
Gaiman.
Good morning, Judge Pillard, and may it please the court. My name is Julian Gaiman. I represent Amateur Radio Emergency Data Network, or ARDN. So I'm going to follow up on the judge's questions about how the order is inconsistent with the transportation statute. And as set out in our portion of the brief, our theory is that the FCC has limited rulemaking authority, limited to the final rule being not inconsistent with law. So I'm going to quickly run through 3 ways that the order is inconsistent with the transportation statute. First, the order outlaws DSRC and mandates CV to X. And this is inconsistent with the Congress's instructions that the Secretary must set ITS standards. The FCC is setting the ITS standard instead of DOT. Second, as you were previously discussing, the order finds that 30 megahertz is sufficient spectrum for safety-related functions. This is inconsistent with Congress's requirement that DOT define the communications requirements of the national architecture. Third, the order makes FCC licensees abandon the architecture. These are Mr. Turner's clients who simultaneously have an obligation to the FCC under their FCC license, and also have an obligation under 23 USC 517D to follow the national architecture.
Counsel,
And Mr. Turner's clients.
Counsel, may I ask a question about standing here? Why do you have standing to complain about the change in character in the 30 megahertz bands?
So we are challenging the entire order.
No, I asked, why are you injured by the change in character of the 30 megahertz?
Sure. My clients are amateur radio licensees. They are secondary in status to either DSRC or cellular V2X, either one of those. And so for them, the question is, which system is easier to engineer around and not interfere with? And
Isn't the real truth that you want to keep an outmoded technology so there's more room for you to play?
we take no position on what's current and what's outmoded. From an engineering,
then what is your injury? I don't get it.
From an engineering standpoint, it's easier for amateur radio to avoid interfering with DSRC than it is to avoid interfering with cellular V2X.
Because the original technology is not used at all. So you didn't have to worry about it.
On the contrary, almost every ITS installation in the United States has been using DSRC. And if this order stands, they're going to have to change that technology to go to cellular V2X.
Oh, okay. And why does that cause injury to you?
Okay. Cell towers are about 100 to 300, 400 feet high. When a radio signal is broadcast from a cell tower, it covers a very broad area. By contrast, DSRC, the incumbent technology, uses what are known as roadside units. They're about 25 feet high. They're spaced along side of a freeway or a road. They have a much smaller radio footprint. It's easier for amateur radio operators to avoid that radio footprint than a gigantic one that's put out by big cell towers.
I see.
You're also taking the position that the departure from prior policy violates the TEA, not just the Administrative Procedures Act. And your strongest argument there?
Our argument is focused on Section 303R, the authority to engage in rulemaking. And our argument is that the FCC overstepped its statutory authority to engage in rulemaking by putting out an order that is inconsistent with Department of Transportation's authority.
And the authority that you're pointing to that the Department of Transportation gained in the Transportation Equity Act is exactly what?
23 USC 517A1, the Secretary shall develop and maintain a national ITS architecture and supporting standards and protocols. The definition of architecture includes the duty to define communications requirements. That has to do with how much spectrum is available to satisfy the information flows that the architecture anticipates. Also, supporting ITS standards. As I've already mentioned, the switch from DSRC to cellular V2X, that usurps the Secretary's authority to set that standard.
Do my colleagues have further questions?
No.
All right. And Mr. Gaiman, did you intend to reserve any time for rebuttal?
Yes, 30 seconds, please.
All right, we'll give you 30 seconds after we hear from Mr. Novak. Mr. Novak, you may proceed when you're ready.
Good morning, Your Honors, and may it please the court. The FCC made a reasonable, record-based determination that retaining 30 megahertz of dedicated 5.9 gigahertz spectrum will serve all demonstrated transportation needs and that it's neither necessary nor in the public interest to reserve an additional 45 megahertz of spectrum at the expense of other pressing public needs. The petitioners here have never clearly demonstrated that they would be offering any particular features in 75 megahertz of spectrum that won't be offered in 30 megahertz. And
what about Continental's position that they can't do the non-light of sight collision avoidance without broader spectrum, and Mr. Turner's point that when you recited that the 30 megahertz was sufficient, you're really looking to cellular comments and not to the transportation industry?
Yes, so taking those in turn, first with respect to Continental's comments that were discussing what it called collective reception messages. The problem there, Judge Pillard, is that the petitioners haven't pointed to any evidence in the record to support or substantiate any claims about those features. Vague allegations about what you might hope to do one day in the future aren't enough. There has to be some sort of substantiation, some sort of evidence that this is really feasible and that we're likely to see it deployed. But they haven't given us anything here or pointed to anything in the record other than their own say-so, other than take our word for it.
But isn't there a little bit of a chicken and egg problem here in that these are technologies that to bring them online, it takes a lot of investment, a lot of infrastructure. And so entities need to know, commercial actors need to know, is this going to be there if we build, is the spectrum to use this going to be there? And I take your position to be, if it's somewhat more on the horizon, we would consider it. But what needs to be shown for it to be, for the go ahead to be given? So, what more needs to be shown? Because they are saying, they do make a empirical case that, yeah, it's in the future, but it's coming and it does need more spectrum.
Your Honor, I just, with respect to your point about the chicken or egg issue, the commission made clear in this order, in the further notice proposed rulemaking at paragraphs 189 to 192, that if this technology is one day successfully developed, if there's a need, the commission is ready and able to make other spectrum available. So I don't think that's an issue. Now, I don't think this is a case where this is a question on the margins that might be difficult about when is this technology coming. This is one where there was a real dearth of any evidence in the record to demonstrate when or if it might come to fruition. And in terms of what evidence there might be, if they could point to some evidence that someone has developed working demonstrations of this technology, even in a lab, or is close to doing so anytime soon. But here we have just a dearth of any evidence in the record beyond a self-serving assertion that is not substantiated by any sort of evidence. And the commission reasonably found that given the state of this record, this is entirely too uncertain and remote to justify holding spectrum in reserve at the expense of other pressing needs.
Do you think of petitioner's argument that you could require the development of the technology?
The petitioner's argument, as I understood it, about build-out requirements was not about requiring the development of this particular technology, and we don't have any reason to believe this technology ever could be successfully developed. It's been over 20 years since the spectrum was made available, and there's no evidence that anyone has gotten anything off the drawing boards with respect to this. The argument of build-out requirements was different. That was just saying, we will deploy existing developed features, basic safety messages to 5 million vehicles within X number of years. And that simply isn't responsive to the problems that the commission was dealing with here.
Given the speculativeness, is that something we should look at under the APA, or is that itself a standing problem? The speculativeness of the harm because they haven't alleged enough concrete that they even have a dog in that fight?
It's an interesting question, Your Honor. We haven't challenged their standing here. I do think that it's on very shaky ground. Of course, from our standpoint, we'd be happy to have the court address this on the merits because we think that we clearly prevail on the merits about this. There's got to be, some greater information. And I want to stress that requiring the commission to hold spectrum in reserve and to do so indefinitely, which seems to be what's being sought here, it's been 20 years already, has significant real world costs. So on this record, the commission couldn't justify doing that. And again, if circumstances change and there is a need for additional spectrum later, the commission has said that it stands ready and able to make other spectrum available. But we had to make the decision based on the record that's in front of us. And the record here simply didn't have any sort of tangible evidence that could substantiate any representations that were being made about this technology.
Can I ask you about the duty to consult? What do you think that entails? The record does not suggest that the commission did any outreach to the Department of Transportation other than the notice of proposed rulemaking and accepting comments.
I don't think that's correct with respect to the record, Your Honor. And I'll just point out that as several judges recognize, the petitioners didn't raise this argument in their opening brief. So we didn't have an opportunity or occasion to go into more detail. But the record here establishes that the Department of Transportation provided multiple rounds of feedback, not just on the public NPRM and the order, but that the FCC shared with them private advanced drafts before anything went out to the public, and there were private advanced consultations. You'll see
Where do we see that? Yeah, go ahead.
Sure. So pages 386 to 414 of the joint appendix is a letter from the Department of Transportation commenting on a private pre-release draft of the notice of proposed rulemaking. Pages 563 to 576 is a letter from the Department of Transportation commenting on a private pre-release draft of the order. And the record reflects the commission made modifications in response to those private Department of Transportation comments before anything ever went out to the public. You'll see that, for instance, at page 536. And then on top of all of that, our staff informed me that prior to the coronavirus pandemic, there were in-person meetings between FCC staff and Department of Transportation staff to discuss these concerns. So I think by any standard,
the timing of those, even generally, I mean, it was before this order went out?
Yes, Your Honor. So we simply think that by any reasonable standard, there was ample consultation here.
That's very helpful.
The
you may have already said this, but I think part of a compound question that I asked you was what would be enough? I mean, I think it was Continental says, actually this non-light of sight perception and maneuver coordination technology is like within 3 years of being able to be deployed. If they had evidence of that, is that enough? I mean, again, there's this issue of investment and reliance planning. What is enough for some future very beneficial safety technology to command the commission's interest in terms of spectrum allocation?
So there has to be, some level of substantiation, and we fully recognize there could be close cases. I do think if there was evidence of significant development that gave real reason to believe that this was likely to be deployed within 3 years, within some reasonably foreseeable amount of time that might let you make some sort of reliable predictions. The issue here, of course, is just a complete dearth of evidence in the record that I think makes this an easy case and doesn't provide cause to hold spectrum in reserve. And I think the commission pointed additionally to the fact that this is not something new. This is spectrum that was allocated originally in 1999, and you don't see any meaningful deployments, even of quote unquote existing features that have been developed, which really calls into question any predictions now being made about the future, about advanced technologies that, as far as we can tell, are not meaningfully in progress in a way that gives any degree of confidence that this is something that could be deployed. I think in this circumstance, it was entirely appropriate for the commission to decide that as between holding spectrum in reserve at the expense of current pressing needs, or dealing with other present needs, and given the availability potentially of other spectrum should this technology be developed, this was an eminently reasonable decision, I think, under the APA.
How difficult is it to claw back spectrum once it's been allocated to unlicensed use as here? And when you talk about other spectrum, that wouldn't be adjacent, would it? So how much does this foreclose rather than just postpone the kind of consideration that Mr. Turner's clients are asking for and Mr. Gaiman's clients are asking for?
So, Your Honor, I think you're right that, we're not suggesting that it would necessarily be clawing back the same spectrum here. But my understanding of the record is that any mid-band spectrum would suffice. There's different spectrum ranges that have different properties, but this non-line of sight property is not limited to this narrow 45 megahertz we're talking about. It deals with an expanse. And I think you'll see that the commission has been actively engaged in a number of techniques to make spectrum available when needed. I mean, you see it here, we're able to move spectrum around. If you look at the PSSI case, it's heavily cited in the briefs. The commission took steps to make additional spectrum available. So there's been no reason to think that it wouldn't be possible to make suitable spectrum available. We're not saying it would necessarily be the same particular 45 megahertz of spectrum, but nothing here rises to the level of a showing that the commission wouldn't be able to suitably deal with this problem were we to ever hit a point where this appeared to be a problem.
My only other question is about whether it really is reasonable to say that this duty to consult with and consider the spectrum needs of the intelligent transportation system was a one-time deal in 1999-2000, and whether you're really taking the position that the obligation of the commission, apart from sort of the ongoing APA obligation to consider all comments, that the obligation under the Transportation Equity Act is over.
Your Honor, it's not a position that we're pressing. I mean, we're not arguing we didn't need to consult. We're telling you we did actively consult, and simply as a good governance measure, you're going to expect agencies like the FCC to do this. So I think that's a little bit of a moot issue. I do see that it's a little bit questionable whether that consultation is required, but the commission here chose to do so. Now, what Mr. Turner was pointing to on this, I believe, is paragraph 123 of the order, and I think the petitioners have persistently misread what's being done there. And I think it's helpful to step back and recognize there are really two different doctrinal issues here that is important to keep analytically distinct. One is the question of whether the FCC had statutory authority to manage the spectrum. And then there's a separate question under the APA about whether the commission's exercise of that authority was reasonable. And paragraph 123 of the order was responding to arguments about the commission's statutory authority. The heading there is statutory considerations. It refers to statutory duties, and it correctly says that as a purely statutory matter, the Transportation Equity Act simply directed the commission to conduct a rulemaking and to consider the spectrum needs of vehicular communications, and in no way restricted the commission's statutory authority to manage that spectrum. Now, whether a given action taken under that authority is reasonable is really a separate question under the APA. And when managing spectrum for vehicular communications, the commission always has considered policy goals like those in the Transportation Equity Act that Congress has set forth in other relevant statutes.
My colleagues have questions?
No,
Let me ask one question about the future. Before I do, let me see if I have my terminology right. The spectrum that's been newly made available, is that spectrum for unlicensed Wi-Fi uses? What's the right term for that?
Yeah, so the right term would be that we have repurposed the lower 45 megahertz for unlicensed use.
Okay. Well, let me ask, am I right that there's a very broad range of spectrum beginning around 5 gigahertz that's now available for unlicensed use? And then there's also a very broad range of spectrum beginning at 6 gigahertz that's available for unlicensed use. And the only thing in between those two very broad ranges are now this very small sliver of 30 megahertz for intelligent transportation. Is that in the ballpark of correct?
My understanding is a little bit more complicated than that, both with kind of what the quantity is in the 5 gigahertz band. I think it's around kind of 5.8. And I'm not sure whether there's anything else that potentially could operate in the middle. I mean, this 5.9 gigahertz sliver is not just intelligent transportation. It's never been exclusive to vehicular use. It's available for amateur radio operations, for instance. That's why we have the amateur data network as petitioners here. So that's always been shared between a few things, but I think that's generally correct.
So that might moot this question, but how much jeopardy is that remaining 30 megahertz in the future, if it's the only thing standing between what would otherwise be a very, very kind of uninterrupted spectrum for unlicensed use?
I guess there's maybe two things that you might mean by jeopardy, Your Honor. One is kind of just an interference question, and the commission here put in place ample interference protections to ensure that would not suffer harmful interference from unlicensed use in adjacent bands. And then, if you're asking about whether the commission might ever consider trying to reallocate this 30 megahertz, there's nothing on the horizon for that. If anything, I think what you'll see in this order is the commission embraced the importance of retaining it for vehicular communications and went out of its way to set up limits on adjacent use. I mean, for instance, you'll see that the power level restrictions that we imposed on wireless devices are less than what wireless interests wanted. They wanted to be able to operate at higher power levels. And the commission said, no, we are serious about retaining this spectrum for vehicular use and protecting it. We do value the features that are being provided in those 30 megahertz. So I don't think there's any reason to think that spectrum is jeopardized given the commission's actions here.
That's helpful. Thanks.
If there are no further questions from the court, then we simply ask that you deny the petitions for review and affirm the commission's order. Thank you.
Thank you, Mr. Novak. Just want the record to reflect that Mr. Leach is here from the Justice Department. He's here, I take it, in response to the order of the court to help us to understand why the Department of Justice wrote the brief, not the FCC, and what we're to take from that, given that the Department of Transportation would ordinarily be represented by the Justice Department and the FCC by itself. Does anybody have questions for Mr. Leach before we proceed to rebuttal?
I thought his letter made clear.
All right, we appreciate your being here, Mr. Leach, the courtesy that shows to the court in case we did have follow-up questions on the issue identified in the order. So we'll proceed to hear briefly from Mr. Turner and then even more briefly from Mr. Gaiman in rebuttal.
So thank you, Judge Pillard. I just wanted to hit one point. You mentioned regulatory certainty, and isn't regulatory certainty important? And it absolutely is. And one thing that the commission has not talked about, and they sort of don't talk about at all, is that the commission itself played a huge role in making sure that these deployments didn't happen. And as we mentioned in our brief, in 2018, 2 commissioners sent a letter to the Toyota Motor Company saying, hey, we understand that you're about to deploy DSRC radios in your 2021 model year cars. We want you to be aware that spectrum may go away. And Toyota received that message and did not deploy those radios in its car. And so I think it's important to understand that when the commission says, hey, there's no evidence of commercial deployment, current commercial deployment, that's the language that they use in the order. What they're saying is our efforts to make sure that deployment didn't happen prior to this order taking effect were effective. And Toyota got the message and didn't deploy the radios that it was otherwise planning to deploy.
The example that you use is of DSRC. You're not objecting to the shift away from DSRC, but you're using that in a more illustrative way that,
correct,
that there's a sort of a signaling back and forth when the commission says we're going to be stingy about something, then the industry is going to be prompted not to do the very development that the FCC would need.
Correct. And if your honors haven't had a chance to read that letter, that's J579, I would urge you to do so. It's pretty brief, but it's kind of a striking illustration of what we're talking about. Because yes, it's illustrative of industry receiving the message from the commission that the spectrum is in jeopardy and not wanting to devote precious time and resources to deploy spectrum or to deploy technologies that are not going to be, they're not going to be able to use.
But we don't have a similar letter. I mean, I understand that at the general level that that's an example, but we don't have such a back and forth about the taking away the 45 megahertz of the spectrum. That's an analogy you're making about the DSRC, to which I understand Mr. Gaiman objects, but I understand you're not objecting.
Well, no, Your Honor, I want to be clear about this, because what the FCC says is that this spectrum, and Mr. Novick said this in his presentation. He said, one of the reasons that we don't believe that the additional 45 megahertz is necessary is because we don't trust what the Department of Transportation is telling us. We don't trust what the transportation sector is telling us, because they haven't deployed even DSRC, even the basic safety message, in any commercial deployments to date. Now, that ignores, as I already said, that there are tens of thousands of these things out there that have been deployed by my clients. But it also ignores that the reason that there were no commercial deployments is in part because the commission was very clear that it didn't want those commercial deployments to proceed. And so it's a twofold thing. Yes, it's about regulatory certainty. And there has been plenty of other regulatory uncertainty in this proceeding, not just that Toyota letter. There was the testing program that the commission walked away from, right? The commission had this program to decide whether or not it was possible to share these resources. That was going pretty well, but the commission decided, no, we weren't going to.
All right, yeah, we're familiar with the record, and I'm sorry to cut you off after I used some of your time with questioning, but unless my colleagues have questions for
Well, Your Honor, if I could address the point that Judge Walker made about surplusage. He asked me to look in the brief.
Oh, yes.
And yeah. So I just wanted to point out in page 37 of our brief, we say the commission seeks to read this provision out of the statute, violating an elementary canon of construction, talking about the duty to consider in consultation with Secretary of Spectrum Needs. We didn't lay that argument out fully in our opening brief, because it wasn't until the commission's brief that we saw the commission say, oh, well, we did consult. And it was only once we had them saying, oh, no, actually, we did consult, and sort of pointing to the Kitawa case and saying that's a consultation case. I mean, they know how to make the consultation argument. It was only once we had that argument in their brief that we had to respond to it in the way that we did in our reply. So I think we've preserved that argument because we were the ones who first raised the idea that they had ignored that duty in the statute.
Thank you. All right, Mr. Gaiman, we'll hear briefly from you. Can the court clerk help Mr. Gaiman? He's having trouble unmuting. I don't know if that's all within his.
As that Mr. Gaiman requests to unmute, Mr. Gaiman, there should be a box on your screen. If you could just click OK or accept. I believe Mr. Gaiman is probably switching to his phone audio.
I have nothing further. All right. Thank you for your ingenuity in communicating with us. And we appreciate the arguments of all counsel. The case is taken under advisement.
Case number 21-5083, Jean-Gabriel Bernier versus Jeff Allen, Chief Physician, FBOP Appellants. Mr. Himmelfarb for the appellant, Mr. Howard for the appellee.
Good day, Council. Mr. Himmelfarb, you may proceed when you're ready.
Thank you, Your Honor. May it please the court, Edward Himmelfarb of the Department of Justice, representing Dr. Jeff Allen, the Chief Medical Officer of the Bureau of Prisons. Jean-Gabriel Bernier is a former federal prisoner who was cured of hepatitis C while in prison in early 2017 with a direct-acting antiviral drug called Rebuttal. Almost 5 years later, Bernier is still pursuing this Bivens action because he had been turned down for a treatment a little over a year earlier based on BOP's earlier protocol, which was designed to provide treatment with antiviral drugs to those prisoners in greatest need. The two new allegations in the second amended complaint that convinced the district court to deny qualified immunity to Dr. Allen are first, that the entire BOP protocol, treatment protocol, had no medical justification whatsoever and was totally based on the cost of the treatment. And second, that Dr. Allen was personally aware of some older blood test results for Bernier from his time in state prison. Now, both of those allegations, there are two problems with each of those allegations. The first problem, if you look at the protocol allegation, the first problem is that we're talking about the Bivens action. There is no allegation in the complaint, the second amended complaint, that Dr. Allen was in any way responsible for this protocol. The protocol, if you look at paragraph 38 of the second amended complaint, which is on page 115 of the joint appendix, what it says there is that BOP was responsible for this. It uses the term FBOP, Federal Bureau of Prisons, but that's what it's talking about, that the agency was responsible for this. So since Dr. Allen is not being alleged to have created this policy, he should not be sued in Bivens. The second problem with the protocol allegation is, as we spent a lot of time in our brief talking about, that the idea is that it was somehow, the idea that it was based on cost alone and had no medical justification makes no sense in the context of the exhibits that were attached to the complaint. Those exhibits include not only the BOP protocol excerpts, which show that it had medical justifications, but the press release and the new protocol by the two medical organizations that the BOP, whose original protocol, BOP's protocol, was based on. So if the medical organization's protocol on which the BOP protocol was based, in fact, the complaint says that it was analogous to the medical organization's protocol. If the medical organization's protocol was based on medical justification, then it necessarily follows that the BOP protocol was based on a medical justification.
I'm not so sure about that, Mr. Himmelfarb, because there isn't any allegation or suggestion that the reason the medical association said to direct it to the sickest was to direct it to the people who would most benefit, or to ration it because of any shortages of availability of the direct acting antiviral, or because of shortages of staff. The only reason I see in the incorporated document is that the direct acting antiviral drug, there were concerns about safety that had not been adequately dispelled. And in its 2015 announcement, the medical associations explained, we need to gain experience with their safety. We needed to gain experience with their safety before we encouraged all infected persons to initiate therapy. So it made sense, if you're worried about the safety of a drug, you might be willing to prescribe it to people who are really on the brink of death. And you might not be willing to prescribe it more broadly because its risks to the health of patients are greater than its potential benefit. And then what happened as I understand it, in 2015, is that the medical associations gained confidence that it wasn't risky and therefore should be made available to everyone else. So once that's been announced, it seems to take away the medical justification, which was that kind of cost benefit. That's shifted that completely. So continuing to rely on it, there might be other reasons, but the fact that the prior medical consensus tracked what BOP continued to do does not seem like support for your position.
Well, Your Honor, there are a couple of things in response to that. One is, if you look at Exhibit C, the press release accompanying the new protocol for the medical organizations in October 2015. It says, because of the cost of the new drugs or regional availability of appropriate healthcare providers, a practitioner may still need to decide which patients should be treated first.
Right, but that's a different point. That's a new and different argument from the one that they note above that they had relied on. And we don't have any information at the pleading stage whether the Bureau of Prisons was making decisions on either of those grounds. We don't know anything about the cost structure, whether BOP spends money and then, reports that it needs that same amount or more the next year. We don't know anything about how hard this is to deploy. I mean, we're at the pleading stage here. So what Alan asserts and what the plaintiff claims is that the Bureau of Prisons just stuck with the old medical association's view after its own ground was abandoned.
Well, Your Honor, just to respond to that quickly, the change came in October 2015. BOP gradually changed its protocol over the course of the next year, and the application from Bernier came in December 2015. In other words, 2 months after the change. The decision of the district court in on the first amended complaint made the perfectly reasonable point that DOP cannot be expected to change on a dime. It would take a long time. And in fact, if you look at Bernier's brief in this appeal, look at page 21 of their brief, they talk about how this qualified language in Exhibit C and D, about how this new protocol make time to implement in certain unique settings. They say that, let me see if I can get the exact language here. They say this was merely a recognition on the part of the panel of the medical organizations that implementation of the new protocol might not be instantaneous due to non-medical factors. And so if you think about what happened between October 2015 and December 2015, that's certainly a question of how long it takes to implement a new policy. And as I said, BOP implemented this new policy over the course of the following year, and it ended up with a different policy. And under that new policy, Bernier was eligible for treatment with these antiviral drugs, and he did get the treatment, and he's been cured. The complaint says he's been cured.
He had a pending request at that time, though, and we know that this is a very severe disease. Indeed, can be life-threatening. He also, and we haven't talked about the knowledge allegation directly yet, and I hope we will, but taking that in the light very favorable to the plaintiff would be that he had cirrhosis of the liver. And so one question is, even if it would take time for the protocol to change, why wasn't it incumbent on the medical personnel to prescribe these direct-acting antivirals to someone presenting at least with some evidence of cirrhosis?
Your Honor, if you look at the complaint, I'll give you the page number in a second. He was returned to federal custody in sometime in the early summer of 2015. So he was there for a few months. He was tested repeatedly. There's an allegation in here, his own complaint. I'm not quoting from somewhere else. He quotes the clinical director, FCI Allen, where they're saying that as of the examination date, which is August 2015, Bernier has not had any clinical symptoms of cirrhosis. So that was the evaluation a couple of months before his application was submitted. And if you look at,
but just on that point there, Mr. Himmelfarb, the complaint also at JA 109-110, paragraphs 15 and 16, includes, which Bernier not surprisingly cites in his brief, it was acknowledged by medical health providers at the facility that plaintiff's chronic noted health problems included hepatitis C and cirrhosis of the liver. Right.
But I think what you need to look at, remember, we're talking about Bivens' action against the chief medical officer of BOP, not against any of the personnel who examined him at Allenwood. None of those people are defendants in this Bivens case. And so the only thing that
Because
Dr.
he was the decision maker. They recommended, they sent the request up the chain.
That's
But
correct.
Alan was the decision maker.
That's
So-
correct. That's correct. But his decision was based on his Exhibit A. There's a one-page Exhibit A. And if you go through this, it has a APRI test from December 15th. So it was about 2 weeks earlier than Dr. Allen said that he didn't qualify. The APRA was 0.40. The priority requirement to get these treatment with these drugs at the time was 2.0. So it was a recent, extremely recent test. It was very low. They also came with a liver biopsy report that was somewhat older, showed stage 2 fibrosis. They had a normal endoscopy the month before this request was put in. It says he appears to be priority level 3. Current APRI of 0.402. And
the difficulty is for us, Mr. Himmelfarb, I realize that there's other indicia in the record. The difficulty for us, we're certainly not medical personnel, but there is also in the record by the Bureau of Prisons' own medical providers, a statement that plaintiff's health conditions included cirrhosis. And we also know from BOP's own policies that it doesn't look only at APRI, other indicia of cirrhosis are relevant. And we know that biopsies of a massive and formless organ like the liver, that sometimes you don't get the
that's correct.
The tissue that's scarred. And so I guess just the question is not whether he wins on this record. The question is whether he's entitled to proceed at all with the claim for factual development.
Your Honor,
I
think your question leads into the issue of Dr. Allen's awareness of this,
right?
Because you're quoting something that there's no evidence in the record whatsoever, or no allegation in the complaint whatsoever that he was aware of that. He was that the allegation.
There is an allegation, and I understand that you take it to be, you characterize it as conclusory, but there is an allegation that Dr. Allen, as well as the clinical director Stahl, were aware of this, and that was something that the district judge was willing to accept. But go ahead.
I beg your pardon, Your Honor. But what it says they were aware of was the FibroSure scores from his time in state prison, not any of these other things that we've been talking about. Only the FibroSure scores. That's what the allegation is about. And the point is, I
didn't see you arguing that the FibroSure scores didn't register a cirrhosis level of number.
What we're arguing is that there are many different kinds of indicators of tests for cirrhosis. And the different medical providers use different tests. They're all, they can argue about which one is better than which one, but APRI is a recognized indicator. They had a reading of this, not from 2011, 12, 14, whatever the state FibroSure scores were, but from December 2015, just 2 weeks before the decision was made about his priority. And so even if Dr. Allen had before him the state FibroSure scores, which is no evidence of, even if he had before him, it wouldn't make a difference. It's still a medical judgment how to balance two different indicators, two different tests.
But we don't have, I guess the question is what would permit us, in light of evidence, so we have the knowledge question, we actually have to talk directly about that. But if Allen did know the statement that is in the medical record below, which is plaintiff's chronic health noted problems, including cirrhosis, if that were something that Allen saw, we don't know at the pleading stage. We can't just say, oh, there's other stuff too, balance it out. We have to hear how those things are balanced.
Your Honor,
doctors.
I have to come back to the point that there's no allegation that he knew that. There's an allegation.
Okay, that's a separate issue.
FibroSure scores. So we have to distinguish between the two.
Right. That's a separate issue. So the allegation that he knew the FibroSure scores, and are you contesting that if he knew the score, that he would also read it to indicate cirrhosis? I didn't take that to be an argument. He knows the score, and if he credits it over other evidence, and I realize those are all matters not to be resolved, but if he knew the score, that would be a cirrhosis score.
And there were
And
non-cirrhosis
the question is that he
scores.
doesn't, right. So there's,
Non-cirrhosis scores too, and you, as a
Right.
medical professional, you need to balance the evidence before you. And you cannot say that a medical professional who's balancing the evidence before him is violating the Eighth Amendment, deliberate.
we're not the medical professionals, but let me just ask the knowledge question. So it was acknowledged by the providers at the facility that his noted problems included cirrhosis, and that they acknowledged test results, 3 different test results earlier. We know this is a disease that doesn't tend to spontaneously resolve. It tends to progress and worsen over time. And we know that the Bureau of Prisons acknowledged that an APRI score is not necessary for diagnosing cirrhosis. It may be diagnosed by other means. And I hear you that you're saying just because there's one indicator and there are other tests that show to the contrary, maybe those other tests in medical judgment prevail. I hear you on that, but I'm just saying we read the complaint and the light most favorable to the plaintiff. So one indicium, cirrhosis. And yes, we know that it wasn't included in the report that went up the chain, that the reference to cirrhosis, but we also know that this is a plaintiff who acted with alacrity. He tracked the changed medical consensus. He requested this direct-acting antiviral treatment as soon as it was available. He was a squeaky wheel. And just the fact that it wasn't on the paper does not exclude the possibility that there was discussion between the immediate care providers for this squeaky wheel who referred this request up the chain, and the ultimate decision maker. We just aren't in a position to say that at this stage, are we?
Yeah, I think you are, because if there were any such evidence of Dr. Allen's awareness of this, Bernier would have pleaded it. There is no plea.
Well, no, but I mean, I don't understand that, because in your own briefing, Mr. Himmelfarb, the blue brief, you say, Dr. Allen's subjective awareness is a matter that Bernier could not conceivably have personal knowledge of. I'm quoting your brief. And in the gray brief, merely offering a conclusory allegation that Dr. Allen was subjectively aware of the FibroSure results, a matter that Bernier could not possibly know. I mean, this is a familiar problem, right, in the legal system. When we need facts, and especially facts with some expertise brought to bear, we sometimes have to proceed to discovery, don't we?
Not in this case, Your Honor, because what he could have done, we mentioned this in our brief too. What he could have done was he could have said that I spoke to the clinical director at Allenwood, and he told me that he had had personal phone call with Dr. Allen in Washington, and that they discussed the FibroSure scores. That would have been perfectly enough. We would not be here arguing that that was not good enough. The problem is when you make something up entirely like this, and again, let me say, it's limited. The allegation that he was aware was limited to FibroSure. It had nothing to do with any of the other test results or any of the other things that were done to Bernier during that several-month period. It was limited to the FibroSure results. If you have no basis for saying that he was subjectively aware of it, that's not good enough. Anyway,
it's a reasonable inference from the treating people knowing it and writing it down, and the patient asking for it early, and the people. I mean, often if people refer something up for with a recommended treatment and they get a no answer, they might well follow up and say, hey, Alan, let's talk about this. This guy has cirrhosis diagnosis that he's pushing on. What do we do about that? I mean, it's very possible.
I think, Your Honor, I think if they had problems.
Are we mixing up two issues here? Whether or not Alan, your position is there's nothing in the pleading other than the inference that he looks at evidence generally to suggest that Alan knew about the FibroSure test. Isn't that correct?
Yes.
Zero. And under ICPA, what's your analysis?
Oh, this is that the allegation that he was aware is a conclusory allegation that has no factual basis for it. And so it should not be considered assumed to be true.
When
Can I
the-
ask you to this goes back a little bit to the whether there was any non-cost reason for the policy. Can you give us an example of someone outside of prison at the time, December 2015, that this decision was made, who would have been denied this treatment under the medical association's protocols?
Under the old one or the new one?
The new one, the revised one that was in effect in December 2015. Someone outside of prison with Bernier's condition who would have been denied this treatment. I suspect there are people. I'm just wondering who they are.
You skim through the Exhibit D. It goes through a whole bunch of different categories of people, some of whom would not be given the drug here. That's why I talked about unique settings, and I talked about continuing concern about availability and cost. So yes, there are some people. Maybe the availability might be in remoter areas, rural areas of the country. There are people who are drug users who probably would be medically indicated not to get this drug. HIV, there's a section on HIV-infected men, incarcerated persons, persons on hemodialysis. So yes, the policy itself sets forth a bunch of different situations in which non-prisoners would not get this treatment either under the new policy.
Counsel, may I ask a question about the law cases? Seems to me, is it fair for me to conclude there's a conflict between the Third Circuit and the 11th Circuit on roughly similar cases?
Well, are you talking about the Abu Jamal case in Third?
Yes, Jamal in the Third Circuit and Hoffer in the 11th Circuit.
The answer is that that different courts have handled this a little bit differently, but yeah, I mean, I think that
Hoffer makes the point that to make out a case of deliberate indifference, it would have to be more than gross negligence.
well, that's what Farmer said. I mean,
And
Farmer,
indeed, and Estelle versus Gamble, Justice Marshall made clear that malpractice would not be a case of deliberate indifference.
that's correct, Your Honor. And so, I think it was Farmer's the case that said that the state of mind for a deliberate indifference case is criminal recklessness. And so malpractice is definitely below that standard. It's not, it doesn't rise to that level. And so if there's evidence of a balance that a medical professional could reasonably balance, then even if he was aware of the FibroSure scores, then he should have had qualified immunity here.
Because in the Third Circuit in the Jamal case, the language which the district court relied on is or prevents an inmate from receiving recommended treatment for serious medical needs. Do you disagree with that? That sounds pretty inconsistent with Stell versus Gamble to me.
Well, I think you would still, in that situation, you would still need to have the state of mind of criminal recklessness. It would not be enough to think of it as negligence. It had to be criminal recklessness to get to the Eighth Amendment violation. And so whether it's consistent or not, I think you have to read it to include the criminal recklessness subjective standard.
Yes, that's why I'm inclined to think the 11th Circuit view is quite different from the Third Circuit.
Okay, yes. I'm certainly willing to accept that. Yes, Your Honor.
So Mr. Himmelfarb, we talked about the protocol and that it was, something like a year later that the Bureau changed its protocol after the medical associations came out with a new recommendation that virtually all patients should get and would benefit from direct-acting antivirals. And, one can imagine all kinds of reasons that it might take the Bureau some time how do we at the pleading stage, help me out, how do we evaluate that delay? If you had, and I understand your position on this plaintiff, but if you had a patient who was at the threshold of cirrhosis, wasn't under the old protocol eligible, but really would benefit and needs it to prevent permanent liver scarring, but the Bureau takes time. Like, how do we think about that at the pleading stage?
Well, Your Honor, I just want to emphasize what you said at the beginning, which is that we're not talking about this case, because in this case, it was only 2 months after the change from the medical associations. And Bernier himself, in his brief at page 21, admits that it was going to take some time to implement the new policy. So going to your more specific question, BOP is a very large organization, I have to tell you. The entire federal prison system, and as of 2015, there were approximately 200,000 prisoners in many different institutions across the country. And so organizing medical treatment for the prisoners is always very difficult. And when it's a new treatment, it's especially difficult. You're going to need things like, you're going to have to make sure that your medical staff is properly trained. You're going to have to, there are a whole bunch of considerations that go into it. And so it's not like a doctor's office.
No, I understand. I'm just asking for help. How do we, because it seems to me a very factual issue. And if the Bureau were here with a couple witnesses explaining how they take up new advice, how they expedite, how they deal with people who may be harmed during the bureaucratic process, that would be an easy case to credit.
Well,
but we don't have that. And so I'm asking you at the pleading stage, at the pleading stage, what are the tools? What's the best case for us to accept a delay that, reading the complaint in the light most favorable to plaintiff, could be a very damaging
Let me just
delay.
go back to the point I've made before, because I think it fits in here in response to your question. The question here is not a delay of a year. The question here is a delay of 2 months, because the only issue here has to do with the treatment of Bernier or the request for treatment for Bernier in December 2015, only 2 months after the change.
That's not quite right. I thought your own position was that this was a denial at the time, but that because they were continuing to monitor and manage every case, including Bernier's, that if after 4 months or 6 months or 8 months, they were able to provide it, they would. So I'm pointing to the delay of a year, because that's when they changed the protocol and actually give him treatment.
That's right, Your Honor. But I don't see that as inconsistent with what I'm saying. The only issue here was the denial in December 2015 a violation of the Eighth Amendment. That's the
continued denial until it was given.
I think the issue is the denial in 2015. We're talking about.
I thought Dr. Allen's position was we were appropriately monitoring him.
Well, that's correct. But the legal issue here is what happened in December 2015.
Right. I'm not sure this is actually responsive to the question. Are there cases, is there a doctrinal way to help us think about and excuse a year's delay on the government's part, assuming there will be some patients during that year who, had the medical association's protocol been more quickly implemented, would have avoided serious and permanent harm to their health or even death?
Your Honor, I think if you look at the August 2019 opinion of the district court, when it granted qualified immunity on the first amended complaint, there's a discussion in there about the rapidly evolving change in the medical understanding of this disease.
I understand there's a common sense way to reason it through. I'm asking for legal and doctrinal authority that gives us a way to make this point. Legal, like what's the legal framework for us to excuse governmental delay? I understand there must be in every case. This is a complicated bureaucracy, as you said, and I think I'm trying to actually ask.
The doctrinal rubric is clearly established. There's no clearly established violation of the Eighth Amendment in this case, and that's the rubric. That's the doctrine.
Counsel, may I ask about the monitoring? What did the monitoring consist of?
Well, prisoners are often, especially ones with recognized diseases, are certainly able to go and have tests done at their institution. So it's that kind of monitoring to see whether the condition is changing for the worse, to see whether their priority would change.
Was there any indication that his situation was changing for the worse? He was in category 3, right?
That's correct.
And how was category 3 designated?
What were the rules for category 3?
Yeah, what's the description?
Well, I think it's best if I read you from and tell you what the page number is and refer you to that page. Category 3 is on Joint Appendix page 128. What it says is intermediate priority for treatment, stage 2 fibrosis on liver biopsy, APRI score of 1.5 to less than 2, diabetes mellitus, and porphyria cutanea tarda, which I admit I don't understand, but there are various medical indicia that would put an individual in prison in this category 3.
Was there ever an indication that he went up to category 2 or 1?
Under the old protocol, no. What happened is that BOP changed the protocol, and it allowed treatment of people who were not.
No, I understand that, but was there ever a change in his status from before the new protocol came into effect?
No, and certainly not alleged in the complaint. No.
Other questions, Judge Walker? Judge Silberman?
No other questions.
All right, thank you very much, Mr. Himmelfarb. We took you with largely with my questions way over your time, but we will give you some rebuttal time after we've heard from Mr. Howard. Thank you. Mr. Howard, you may proceed when you're ready.
Thank you, Your Honor, and may it please the court, Theodore A. Howard for the appellee, Jean-Gabriel Bernier. Given the nature of the questioning of Mr. Himmelfarb, Your Honor, although I had intended to focus initially on the alternative ground that we believe would suffice to affirm the district court's decision to deny the motion, namely that Estelle versus Gamble in itself is sufficient to establish the clearly established right at issue here. I'll try to focus some of my time on the second issue, which is the sufficiency of Mr. Bernier's allegations at the pleading stage with respect to a cost basis for the determination by Dr. Allen to deny him treatment in reliance on the then existing BOP protocol. And secondly, Dr. Allen's knowledge with regard to alternative information to the APRI test results sufficient to alert him to the fact that Mr. Bernier needed treatment and that such treatment was denied.
Do I take your position to be that the initial protocol was itself indication of deliberate indifference?
No, Your Honor, I can't say that because although it seems apparent that the BOP protocol that was in effect as of December 2015, upon which Dr. Allen relied, was a bureaucratic administrative protocol basically designed to ration treatment to those most in need while
I read your argument as indicating that the initial protocol itself was an indication of deliberate indifference.
Well, Your Honor, I think it
Became deliberately indifferent once the medical associations had made their new.
No, I was wondering, I was really asking whether your position was the initial
Oh,
and
position.
I understand your question, Your Honor, and I understand the basis for it. The basis would be for making that contention would be that in designing a protocol that was premised upon the idea of rationing treatment and only providing it to those in most serious need under circumstances in which this disease, hepatitis C, is a progressive disease that once it starts, doesn't really stop until it's been treated, that the BOP was in effect making a conscious decision that a certain number of people with a progressive disease were not going to be treated until they reached a certain level of severity.
Yeah, so I understood your position. It is correct, as I stated, you believe that the initial protocol itself was an indication of a deliberate indifference because it relied on cost factors.
I think it could certainly be characterized as such, Your Honor.
Well,
but
that's the way you're characterizing it.
Well, that is the way that we've described it, but that is not the premise for our position. Our position is that irrespective of whether or not the protocol was constitutionally flawed prior to the change in the standard of care, certainly after the standard of care was altered such that the authoritative medical authorities that
even in the medical authorities acknowledged there were the difficulties in the prison setting. The medical authorities.
I think that's just a statement of fact, Your Honor, in the policy statement.
It goes to the protocol, doesn't it?
Well, Your Honor, I think that the medical panels were merely recognizing that in an ideal world, these drugs would be implemented immediately, and everyone who has hepatitis C would receive them. And the fact is that probably can't happen, and it probably can't happen in a variety of circumstances, including but not limited to the fact that prisons may have constraints on their ability to implement immediately.
Where do you see that? Actually, the one place in the new medical protocol where incarcerated persons or prisons are directly discussed is a JA 142, where it talks about coordinated treatment efforts within prison systems would likely rapidly decrease the prevalence of HCV infection in this at-risk population. And there's nothing there specific to either, bureaucratic delays or shortage of staff or even cost reference specifically with requests to prison. So I actually don't see that. I mean, I do see which Mr. Himmelfarb's brief quotes that on the sort of cover press release or whatever it is, the first page, JA 130, that the medical associations acknowledge that because of the cost of the new drugs or regional availability of appropriate healthcare providers, a practitioner may still need to decide which persons. That's a very general statement, not at all keyed to prison. So when you talk about some acknowledgement of bureaucratic challenges in prisons, which aspect of the medical protocol are you referring to?
I'm not, Your Honor. It's our position that as of October of 2015, the prioritization protocols that had previously existed or been endorsed by the medical panels on the grounds that pure reliance on clinical trials was inadequate, to give the blessing to the widespread implementation of this new course of treatment. It's our position that was an unequivocal change in the standard of care. the fact that the panels recognized that there might be some instances in which implementation of the new standard of care there might be impediments was not at all stepping back from their determination. This is the course of treatment for people with hepatitis C.
How quickly does the Bureau of Prisons need to integrate a new medical consensus into its protocols for its, in your view, for its action to avoid deliberate indifference? And what case can you point us to that's most supportive of your position?
Your Honor, the case law that has emerged since the direct acting antiviral medications came to the fore has been quite variable with regard to the views of courts in terms of how quickly implementation should have taken place. So I do not have a definitive answer for you with regard to.
But you're arguing, you're asking us to make a decision. How quickly do you believe, are you urging us to hold that BOP needs to act in integrating a new medical consensus? And what's your best case?
Your Honor, I think that well, certainly our position is that by the end of December of 2015, Dr. Allen, who, in his declarations, asserts his own knowledge and expertise with regard to hepatitis C treatment, that if in fact, as we allege, he had sufficient evidence to know that Mr. Bernier had cirrhosis, notwithstanding the APRI tests, then certainly it's our view that he should have acted in accordance with the new medical standard of care and provided Mr. Bernier with treatment.
Is the key to your case that you think he was mischaracterized as in level 3?
No, Your Honor.
So you think the level 3 characterization was appropriate?
By the measures that by which they make those determinations, we have no evidence that that was an inaccurate classification, Your Honor. Our position
You're not making any allegation to that effect.
I'm not, Your Honor. Our position is that once the standard of care changed.
Excuse me, let me just pursue. If in category 3, if I may speak roughly, a person in category 3 was not in danger of life-threatening situation, right?
They certainly, under the classification measures that were used to place Mr. Bernier in category 3, he was not regarded as an immediate danger of the most severe consequences of hepatitis C.
So you're not arguing that the existence of the FibroSure test results alone meant that Mr. Bernier actually had cirrhosis. That's not your argument. Your argument is a more nuanced argument about the protocol and how quickly there's uptake of the new standard of care.
Your Honor, I think that's right. I mean, essentially, after the standard of care changed, the continuing reliance on this classification scheme as the basis for determining who gets medication when was deprived of its foundation.
Why?
And so, I'm sorry, go ahead, Judge.
Why shouldn't we say this? Your case depends on, according to what you just said, the argument that BOP's continuing reliance on its previous system was an Eighth Amendment violation. And you said a few moments ago that courts have been quite variable on that very question, which seems to suggest that even if there was an Eighth Amendment violation here, it wasn't a clearly established Eighth Amendment violation. And that maybe is enough for us to just say that and move along.
Your Honor, our position with respect to that is that there was, from Estelle versus Gamble on, a continuum of decisions by the courts, the federal courts, with regard to Eighth Amendment claims, including hepatitis C cases prior to the advent of the emergence of direct-acting antiviral medications.
Forgive me for interrupting. Forgive me for interrupting you. But in Estelle versus Campbell, Justice Marshall's opinion went out of his way to make clear that malpractice would not be adequate to show an Eighth Amendment violation.
That's correct, Your Honor.
And in the 11th Circuit, they said even gross negligence would not be adequate to allege an Eighth Amendment violation.
Apparently, Your Honor, on the basis of the case you made reference to during Mr. Himmelfarb's argument.
Well, that follows up on my colleague's point. How can it be argued then that there was a clearly established right here, constitutional right, to get the latest, best treatment?
And Your Honor, my answer to that is that, as cited in our papers, there are cases that preceded the advent of this new medical treatment addressing claims by prisoners of denial of care for hepatitis C on the basis of bureaucratic administrative protocols similar in nature to the BOP protocol that was in effect in December of 2015, where courts held that your reliance on this protocol in ignorance of the particular circumstances of this prisoner constitutes deliberate indifference.
Suppose I was a private citizen and went to a doctor with the concern that I had cirrhosis of the liver. And the doctor in December of 2015, or let's say February of 2016, said, I'm a little worried about this new treatment and I'm going to delay it for a while, maybe for 4 or 5 months, if you don't get any worse before I prescribe it. What would you think? You think that's a case of negligence?
I would say it would be under the standard of care that had been established by the medical panels as of October 2015.
So you think you make out a case of negligence?
I think under those circumstances, a case for medical malpractice in the nature of negligence could be made out. Yes, Your Honor.
Howard, you made an allegation that the Bureau of Prisons does not in actual practice perform or accept FibroSure. What's the basis and the import of that allegation in your case? It wasn't entirely clear to me whether that helps you, and if so, why? That the Bureau doesn't in actual practice perform or accept FibroSure.
Your Honor, the premise is that notwithstanding their own written policy indicating that the APRI score is not the be-all and end-all if there are other indicia of cirrhosis, and the fact that in this instance, we contend that Dr. Allen knew of FibroSure results but ignored them, is an indication that they, notwithstanding their own policy saying that other types of evidence can be accepted, they don't actually look beyond APRI.
What is your allegation?
Sure.
Excuse me. What is the allegation that Dr. Allen knew about the FibroSure test?
That is what it is, Your Honor. We have alleged that our belief, Mr. Bernier's belief, that Dr. Allen knew of his FibroSure results.
Well, what do you have other than a bare conclusion? What do you have to support that?
At the pleading stage, we don't have anything, Your Honor.
Well, how do you get by ICBUD then?
Well, Your Honor, I think we get by Iqbal on the same basis as the plaintiff / petitioner in Erickson versus Pardis, as decided by the Supreme Court, got by Bell Atlantic, which was the predecessor of Iqbal and basically articulates the same standard.
That was a pro se case.
It was a pro se case, but that was not the premise upon which the Supreme Court reversed summarily a decision that a magistrate judge, a district judge, and the 10th Circuit had all held that the plaintiff's allegations were inadequate. The Supreme Court said, no, they're not inadequate because under Rule 8A2, he's made clear allegations that are sufficient to put the defendant on notice as to what he's claiming.
Mr. Howard, what are we supposed to do with a decision from a U.S. District Court in New York that had adopted a magistrate judge's report in a suit that Mr. Bernier brought against the state medical doctors who were responsible for his care up until August of 2015? And what the decision says is, and this was on summary judgment, so this was not at the pleading stages. It says that Mr. Bernier failed to show, as of August of 2015, that his condition was such that he faced a substantial risk of serious harm if untreated, much less that his infection was causing him to experience any serious symptoms or ill effects. Now, I recognize that 4 months passed between August 2015 and December 2015 when Dr. Allen made his decision here, but do you think that we're allowed to consider what was found in that U.S. District Court case in New York, and not only consider, what would you say to the possibility that it has some kind of a preclusive effect?
Judge Walker, I have to confess that I am not familiar with the district court decision to which you make reference. I guess neither apparently was Mr. Himmelfarb, because I'm confident that he is quite capable and would have cited it to us.
I thought
I didn't find it myself either. I have to confess.
Without more knowledge,
my crack law clerk found that.
I thought that was cited anyway.
Without more knowledge as to the specifics, I couldn't really say whether it is res judicata or collateral estoppel, but if it went to the question specifically of hepatitis C, I guess that my premise would be that that decision was based on a body of evidence available to that court at that time with respect to a progressive disease. And so it wouldn't necessarily preclude Mr. Bernier from having initiated this case on the basis of the BOP's decision.
Okay.
So I guess I would just say in conclusion that the qualified immunity defense asserted by Dr. Allen has not been rejected. The district court has held that there are allegations in the complaint worthy of recognition. Dr. Allen disputes those allegations. The case should proceed to allow for some exploration with regard to the validity of Dr. Allen's denials. The district court is clearly in a position to exercise its discretion to regulate the conduct of discovery in a way that minimizes inconvenience or consumption of time on the part of Dr. Allen until we get to the point where Mr. Bernier has either established a basis to depose Dr. Allen or the documents that have been acquired through discovery fail to to validate Mr. Bernier's allegations, in which case we probably don't even get that far. However, the allegations were certainly equivalent to those regarded as sufficient in Erickson, in Abu Jamal, in the decision of the Third Circuit. And this court, in the case of Nawab Safavi versus Glassman, 637 F. 3rd 311, a case which we cited in some of our papers in the district court and certainly should have cited in our brief on appeal. This court has certainly recognized that qualified immunity defenses sometimes have to wait adjudication until there has been a development of disputed facts, a record with regard to disputed facts sufficient to allow the court to determine whether or not the knowledge of the defendant indicates that a clearly established right was or was not violated. And we believe that's the case here. And on that basis, we would request that the district court's decision to deny the motion to dismiss be affirmed. Thank you.
Thank you, Mr. Howard. Now, Mr. Himmelfarb, we've offered you some time for rebuttal.
Okay, I have a couple of quick points if the court can stand it. First point is that Mr. Howard was talking about how the new protocol for the medical organizations was a change in the standard of care and that Dr. Allen should have followed it. That's not the Eighth Amendment standard. The Eighth Amendment standard is deliberate indifference. That's a malpractice standard. I think Judge Silberman may have been getting at that point, but that's a malpractice standard, not a deliberate indifference standard. Second point is Mr. Howard mentioned variable court decisions. I think.
What do you mean I may have been getting at that? I was directly getting at that.
I wouldn't want to presume, Your Honor.
No,
Mr. Howard talked about variable court decisions. Well, that by definition means that it's not clearly established. You need more than variable court decisions. This case, remember, just to get back to this basic point, this case is a Bivens action against Dr. Allen. There's no allegation Dr. Allen was responsible for this policy. If Bernier wanted to deal with the policy, he could have brought an injunction suit. In fact, he did that originally. And this court, I believe, in its decision on appeal from the denial of preliminary injunctive relief, said that it was moot because he got the relief. He was given the treatment. And last, I don't know, maybe getting to a little bit trivial points here, but the Erickson case in the Supreme Court, there were a lot more allegations going on in that case than there are here. There were allegations about a syringe, that there was a different treatment, that there's some syringe use, that the prison officials blamed the plaintiff for altering the syringe to use for drug injection. So there were a lot more factual allegations. It wasn't just that it was a pro se plaintiff, which it was, and that's relevant, but it was also a whole bunch of more specific allegations. So unless the court has further questions, we would ask the court to reverse here, to vacate and remand required qualified immunity to be granted.
Thank you, Mr. Himmelfarb. Thank you, Mr. Howard, for your pro bono service. The case is submitted.
Thank you, Your Honor.
This honorable court is now adjourned until Thursday, January 27th at 9:30 a.m.